All right. The Minnesota Workers' Compensation Court of Appeals is back in session. The Honorable Deborah Sundquist presiding.
You may be seated. Good morning. We are here today on the Martinez Cruz versus Metro Transit Police case. It's file number WC 236523. I understand, Mr. Harrison, you are the attorney for the employee appellant, correct?
Yes, sir.
And Mr. Nierstein?
Yes, Your Honor.
You are the attorney for the employer and respondent.
Yes, Your Honor.
You each have 15 minutes to make your argument. If you choose to have some time set aside for rebuttal, I ask that you keep track of that on your own. Mr. Harrison, when you're ready.
Good morning, Your Honors, and may it please the Court. My name is Josh Harrison. I represent the appellant, Mr. Martinez Cruz. Mr. Martinez Cruz comes before this Court today to ask you to issue substituted findings and hold that he did sustain a compensable injury in the nature of post-traumatic stress disorder and remand this case to the lower court for a determination of benefits because the respondent did not rebut the statutory presumption contained in Minnesota Statute 176011, subdivision 15E, Your Honors. It has always been the claim of Mr. Martinez Cruz that a series of events over a number of years led to the development of post-traumatic stress disorder. That PTSD was diagnosed in April of 2021 by Dr. Robert Hoppy, a licensed psychologist. It was stipulated that all the statutory requirements were met and that the PTSD presumption contained in the statute then attached. The burden then shifted to respondent to make a strong showing that Mr. Martinez Cruz did not have PTSD in April of 2021. Per this court and the Minnesota Supreme Court's holding in Junkman, the reports of Dr. Arbisi, who was retained by respondent, cannot rebut the presumption because he is unable to offer an opinion on whether Mr. Martinez Cruz had PTSD in April of 2021.
Mr. Harrison, I'm going to interrupt you fairly early here. Assuming that you are correct about Dr. Arbisi, just for the sake of argument for a moment, even if that is true, can the employer still rebut the presumption if the PTSD is related to an internal investigation as opposed to work events?
Yes, sir. That question is something of a paradox. PTSD can only be diagnosed if it results from exposure to actual or threatened death, serious injury, or sexual violence. So if a licensed psychologist diagnoses an individual with PTSD, they by definition cannot be diagnosing it because of some other type of event. So if you see a licensed psychologist or other medical professional diagnosing PTSD, you know it's not because of those events.
Okay, so let's talk about finding number 51. And it was appealed, but there was no discussion of it in your brief. And 51 talks about Dr. Ekberg saying that the problems are related to an internal investigation. So again, you agree that statutorily and by case law, the presumption can be rebutted by a showing that the symptoms are related to an internal investigation.
Yes, Your Honor. That statutory language is something, this is colloquial, but it's something of a hat on a hat. Medically, it cannot be PTSD if it relates to something else. And so when Dr. Ekberg diagnosed PTSD, and he did in fact diagnose PTSD, that is him saying it is not related to those events. The compensation judge's finding in regard to Dr. Ekberg is clearly taken out of context. And as in Hagen, no reasonable mind, when you look at the preceding sentences, could conclude that is what Dr. Ekberg meant. The preceding sentences read, "This is a 33-year-old male with a history of PTSD, persistent depressive disorder, and generalized anxiety." He is a good historian. I did review the existing medical record. He relates approximately a 2-year history of worsening anxiety, mood problems, and PTSD issues. Your Honors, the internal affairs investigation occurred in February of 2021. Dr. Eckberg's note was from April of 2021. No reasonable mind could conclude that a 2-year history of PTSD issues that Dr. Eckberg notes occurred because of something that happened 2 months earlier. It's just clearly taken out of context. Your Honors, Dr. Arbisi admits in a statement 1 day before hearing that he simply was not provided with enough documentation regarding events and symptoms from Dr. Hoppy's diagnosis for him to tell one way or another whether or not Mr. Martinez Cruz developed PTSD. This is 1 day before hearing. It is his final word on the matter, Your Honors. The inability to offer an opinion is the same as offering no opinion at all. And that was the holding in Junton, Your Honors. Dr. Arbisi there did not opine on whether or not the employee in that case had PTSD at the time of diagnosis. It's the same thing here, Your Honors. Dr. Hoppy was under no obligation to document things to Dr. Arbisi's preference. It was respondent's obligation to engage in discovery before the final day before hearing to get their expert the information he needed.
Counsel, I want to ask you about the presumption, and I know that there's a finding, I think it's finding 49, that the presumption applied and that your client met the presumption, and then there's additional findings after that. And I know that that finding is not on appeal. So I admit those things. But I have a question about the presumption. Was your client last worked on March 1? Is that correct?
I don't recall the last day of it.
Your client went on leave. There's a finding. Your client went on leave on March 1, and then he was ultimately terminated in June. Was there ever a return to work after that going on leave?
No, Your Honor.
Okay, so let's assume he last worked on March 1. Dr. Hoppy writes, I think on March 29, I did some sort of initial assessment. Looks like he has PTSD, and then about a week later, April 6th, he's got PTSD. The statute says that the presumption applies if preceding the date of disablement, there's a diagnosis of PTSD within the statute. I don't know what the date of disablement necessarily is, but it would seem that March 1 could be the last date of disablement if that's his last day of work.
I would just say, as in T, Your Honors, if an issue wasn't raised either at hearing or in the briefs on appeal, it's not something to be considered, and I'm not entirely sure myself, Your Honor. Now, I want to make clear, Dr. Arbisi's testing was limited in both time and scope. His testing was limited to the 30-day window in May of 2022, and we know this by looking at the instructions in the CAPS 5, which is a structured interview that Dr. Arbisi said he conducted. There, if an individual evaluator is conducting a lifetime analysis, they are instructed, and this can be found on page 236 of the record, Your Honors, they are instructed to identify the worst month of symptoms, and if the individual is not experiencing their worst month, then at the time of evaluation, do 2 evaluations of symptoms, one for the preceding 30-day period, one for their worst month of symptoms. As noted in page 13 of Dr. Arbisi's report, Mr. Martinez Cruz was not experiencing his worst month of symptoms when he was evaluated. So if Dr. Arbisi had done the lifetime CAPS, as respondent contends, perhaps he did, there would have been 2 evaluations of symptoms, as well as an identification of the worst month. None of those appear because he chose to self-limit himself in his analysis, which he is allowed to do. He is allowed to offer a narrow opinion. He is allowed to not address the substance of Mr. Martinez Cruz's claim head on if he so chooses. But that won't be sufficient to rebut the diagnosis that in April of 2021, a series of events culminated in a diagnosis of PTSD. Additionally, Your Honors, Dr. Arbisi did not find that Mr. Martinez Cruz did not experience a Criterion A event. He stated that 2 events, in his opinion, were not Criterion A events. However, that is shown to be not true by his own report. In the report, on page 16, Mr. Martinez Cruz identified additional events that were troubling him, including the riots, as well as an incident where Mr. Martinez Cruz and another officer engaged in hand-to-hand combat with a felon.
All right, let me ask you about that, Mr. Harrison. So in Smith v. Carver County,
Yes.
This court essentially criticized Dr. Arbisi's opinion that was adopted by the compensation judge for basically the same reasons. You only identified a couple of traumas. This guy had 15 other traumas. And then the Supreme Court said to us and to compensation judges, no. If Dr. Arbisi said he relied upon the DSM, then he relied upon the DSM, and we're not going to delve into the minutia of the DSM. So let's assume I agree with you that Dr. Arbisi says, well, trauma is only the trauma that I pick, not all traumas. Are we even allowed to look at it?
Yes, Your Honor, because if you look at page 16 of his report, Dr. Arbisi identifies 4 events: the 2 train fatalities, the riots, and the hand-to-hand combat situation I referenced. Then at the bottom of that page, Dr. Arbisi states that dreaming about those events, having distressing dreams, satisfied Criterion B for PTSD. The only way dreaming about those events can satisfy Criterion B for PTSD is if those 4 events were in fact Criterion A events. So Dr. Arbisi, in his own report, agrees that Mr. Martinez Cruz experienced 4 Criterion A events. That also doesn't address the multiple other unrebutted medical opinions regarding events. Your Honors, Dr. Arbisi's report contains numerous errors that respondent knows contains errors. Because if you look at Exhibit JJ, respondent informed Dr. Arbisi, hey, Dr. Slavic diagnosed alcohol use disorder. Yet, if you look in Dr. Arbisi's report, Dr. Slavic's report, page 15, section titled Diagnosis, provides the diagnosis and the medical code. On the following page, there's that diagnosis again in all bold italics. Despite this, on pages 8, twice on page 8, as well as in page 21, Dr. Arbisi critiques Dr. Slavic and Dr. Miles for not diagnosing alcohol use disorder. Your Honors, respondent knew they received a report that was based on incorrect facts. They knew it because they informed him in writing to the contrary. Your Honors, if there's no further questions, I reserve the remainder of my time for rebuttal.
Thank you.
May it please the court, counsel. My name is David Nierstein, and I'm here on behalf of self-insured employer Metropolitan Council. This is a hanging mule case, and the substantial weight of the evidence supports the conclusion of the compensation judge. That's the standard. This is a hanging mule case. One of the main arguments that appellant makes is a critique of the analysis that Dr. Arbisi outlines of criteria A, which is the trauma that's needed for the rest of the diagnosis of PTSD. What appellant overlooks is Dr. Arbisi administered as directed. He evaluated Mr. Martinez Cruz as directed by the administration protocol for clinician administrated post-traumatic stress disorder scale for DSM-5. Mr. Martinez Cruz was asked to identify the worst event or set of events from life events checklist. And the protocol is listed in the exhibits as Exhibit R. And in that protocol, it states the examiner should not suggest responses. In that protocol, it states that, in this case, Mr. Martinez Cruz must identify the trauma. And Dr. Arbisi followed that protocol. And in following that protocol, Mr. Martinez Cruz identified two set of events that would then be analyzed under criteria A.
All right, so let me ask you about that, Mr. Niertsen. Again, we've got Smith v. Carter County that at least I interpret to say judges don't get into the nitty-gritty of DSM analysis. Whether I agree with that doesn't matter. That's what the Supreme Court says. And that's what we're doing right now, however, and that's what the compensation judge did, and so let's do that. The DSM says trauma, criterion A. It doesn't say the most significant traumas, the two most significant traumas, it just says trauma. And as Mr. Harrison said in his argument, Dr. Arbisi does talk about some other traumas that he was aware of. Why don't we just look at all trauma rather than just the most significant traumas as identified by the patient employee?
A few reasons, Your Honor. First of all, I think under Smith, I would agree that the question is, again, I started by saying this is hanging, and I think it is, because under Smith, the analysis should be whether the substantial weight of the evidence supports the compensation judge's conclusion that criteria A was not met. And so I think under Smith, the question is whether the substantial weight of the evidence supports the conclusion. I think it does. But going beyond that, Your Honor, to try to answer your question, the CAPS 5, which is contained in the record, does provide the protocol to determine whether there was trauma that then led to the symptoms for PTSD. And the questions that were asked by Dr. Arbisi were consistent with and followed that protocol. And it makes sense, Your Honor, because the whole analysis of PTSD is that the symptoms that are being claimed in the other criteria all have to flow from the criteria A. And so it isn't just trauma that's listed in the record. It isn't just trauma that the doctor may see in reviewing medical records. It needs to be trauma that is identified while using the protocol to analyze and diagnose PTSD. And Dr. Arbisi followed that protocol. In following that protocol and asking open-ended questions, the employee, Mr. Martinez Cruz, identified two traumas. And that's what Dr. Arbisi focused on because that's what the protocol required.
Okay, so then going to the Hengemule argument, there's two odd findings, finding 20, finding 27, where the compensation judge said, finding 20 is about Dr. Hoppy, finding 27 is about Dr. Slack. The doctors relied upon but did not follow the DSM. I don't even know what that means. The statute says condition as described by the DSM. But what's interesting is that while she said, I am persuaded by Dr. Arbisi's opinion, she did not say that Dr. Arbisi followed, was relied upon, or otherwise used the DSM. She does in her memo, but there's no finding about that. Should we do anything about that?
No, because I think, Your Honor, first of all, finding number 27, Dr. Slavic diagnosed PTSD in reliance but not in accordance with the DSM-5. I don't see that as being appealed. And so I think that's already part of
But I don't even know what it means.
Well,
What's
I
the
think
difference between relying upon something or not following something? I don't even know what that necessarily means.
Your Honor, I think it is addressed in a memorandum, but again, to answer your question, I think that goes to following the protocol. And the determination that is supported by the substantial weight of the evidence is that Dr. Arbisi followed the protocol. And I read the findings that you're identifying as leading to the conclusion that the other providers did not follow that protocol.
The CAPS protocol.
Yes. With regard to the criteria A, Dr. Arbisi, following the protocol that we're discussing right now, went through the 2 trauma, and there's only 4 ways that the trauma can lead to supporting the diagnosis of PTSD. And that is either Mr. Martinez Cruz directly experienced the trauma, that didn't apply. Witnessed the event, that didn't apply. Learned that the traumatic event occurred to a close family member, that didn't apply. So the only way that it could apply, and Dr. Arbisi analyzed this, is under the 4th criteria, which is experiencing repeated or extreme exposure to adverse details of the traumatic event. And examples are given in the protocol of collecting human remains. Dr. Arbisi goes through the record, not just the last 30 days. Counsel argues that the analysis was just over the last 30 days. By definition, criteria A is not limited to the last 30 days. And Dr. Arbisi concludes that criteria A was not met.
All right, so I'm going to interrupt you again. These are one of the events identified by Dr. Arbisi, I believe, is where he comes upon dead bodies on the train tracks, correct?
I don't know that it was dead bodies. I think one, are you talking about for the 2 criteria that Mr. Martinez Cruz identified? One was a woman that was hit by the train, and the other one was a bicyclist that was hit by train.
And he came upon their bodies. He didn't witness them being hit, but he came upon their bodies.
That he was at the scene.
Yeah.
Yes.
And their bodies were there.
Yes.
Okay. And so, again, I'm not a psychiatrist or psychologist, and maybe this is why the Supreme Court told us not to look at this stuff. But if I come upon a dead body or a very badly injured body, whether I saw them get injured or get killed, it's still kind of traumatic to see that, isn't it?
But I think that's where the Smith says the question is whether the substantial weight of the evidence supports the conclusion that Dr. Arbisi reached and that the compensation judge accepted. And really, the compensation judge doesn't dispute, Your Honor, what you're saying. On page 13 of her memorandum, she acknowledges, she says, and she's talking about the criteria A, while no doubt disturbing, the employee did not have direct experience with the traumatic events, and he did not witness the 2 events. He did not collect human remains. He put a sheet over one body and held the sheet down because of the wind. So she addresses what you're asking, Your Honor, and she doesn't dispute that it's traumatic, but that's where we get to, there's a protocol. And under Smith, the analysis is whether I contend the substantial weight of the evidence supports what Dr. Arbisi concluded using the correct protocol. We contend that the substantial weight of the evidence does support that conclusion.
Okay, so it's traumatic, but it may not be a criterion A trauma.
That's correct.
Mr. Nierenstein, I'm going to ask you to comment on what Mr. Harrison said earlier to my question about finding number 51. And the question that I asked him was, assuming that he's correct about Dr. Arbisi, just for the sake of argument, and Dr. Arbisi's opinion should not have been accepted, I asked him if the employer could still rebut the presumption by showing that the condition was related to an internal investigation. And I'm going to summarize. The answer was, it's kind of a circular argument because if he has PTSD, it must be related to an event. Do you agree with that, or do you feel that the employer can rebut the presumption by a finding of symptoms related to an internal investigation?
The employer can rebut the presumption by findings related to an internal investigation. And reading right out of the statute, Your Honor, the mental impairment is not considered an occupational disease if it results from a disciplinary action, work evaluation, job transfer, layoff, demotion, promotion, termination, retirement, or similar action taken in good faith by the employer. It's right in the statute.
Mr. Nierenstein, to follow up on that, does that mean, in your opinion, that if that's shown, or if that's found, like as in this case, we don't even get to the presumption?
Well, I think that the compensation judge determined that we did get to the presumption. I think it's hanging bill. So I think in this case, we're based on what the judge did. I think the question is really just hanging bill. But if you're asking me kind of in a broader sense, yes, I think that one way out is to not even get to the presumption, is to say, hey, this is the result of a disciplinary action. But I think the question here, again, is hanging bill. Does the substantial weight of the evidence support the compensation judge's determination? We contend that it does. The other point I would like to make, Your Honors, is all this argument under Jutnin. Jutnin is distinguishable on a number of different bases. Number one, Jutnin, there's no analysis about any issue on criteria A. In addition to Jutnin, Dr. Abisi specifically testified, I'm only looking back 30 days. So in Jutnin, there was no way for that employer and insured to rebut the presumption because there was no issue when I went through the decision about criteria A. And Dr. Abisi specifically testified, I'm only looking back 30 days. So how could the employer insure about the presumption? That is distinguishable from the present case because number one, there is an issue on criteria A, which we contend is not in existence, and that's supported under Hingenbuell. Secondly, Dr. Abisi nowhere says that he's limiting his analysis for the last 30 days. And in fact, supported by the dispatch weight of the evidence, the compensation judge does a good job of outlining the various pieces of information considered by Dr. Abisi beyond just the last 30 days. And so because Dr. Abisi did not limit his analysis, and because there is a criteria A event, this is clearly distinguishable from Jutnin. In addition, Jutnin didn't address at all the issues that we were just talking about a few minutes ago on the disciplinary action.
I agree with you on that last point, Mr. Ernst, but on the first one, and Mr. Harrison argued this, Dr. Abisi issued a subsequent opinion where he said, and I'm not even sure if he ever had it, which is a little vague. And Mr. Harrison said, well, being uncertain of an opinion is no opinion. So, we'll set aside the disciplinary issue for a second. And just on the issue of the 30 days, that's the implication, at least, that Dr. Abisi wasn't looking at the earlier part in his first opinion. And his second opinion, he said, and going way back, I'm not even sure it was met.
That's not the way I read that comment. And I know what you're talking about, Your Honor, in the supplementary report from Dr. Abisi. That's not the way I read that comment. The way that counsel is reading that comment, I think, is taken out of context. Dr. Abisi clearly outlines his opinion that Mr. Martinez Cruz does not have PTSD. The comment that you're talking about, Your Honor, says that, and by the way, if I'm looking at Dr. Hoppy, I don't even think Dr. Hoppy, you can tell whether Dr. Hoppy was correct in diagnosing PTSD. But in no way was Dr. Abisi indicating that Dr. Abisi was unable to provide that opinion. And so nothing in that supplemental report changes the very clear opinion of Dr. Abisi that Mr. Martinez Cruz does not have PTSD under the statute. Could I have about a little over a minute left, could I reserve that for rebuttal?
Yes.
Thank you.
Your Honor, no reasonable mind could look at the evidence in the record and state that Mr. Martinez Cruz did not experience exposure to death and serious injury and sexual violence. He tore his PCL while chasing an armed felon. Literally the tissue that connected his bones was ripped apart while on duty. How in Hingenbuell, yes, the substantial weight of evidence, but it needs to be an opinion, a decision that a reasonable mind could agree with.
Mr. Harrison, I have a question about that.
Yeah.
Why wasn't this brought as a physical mental injury case?
Yes,
because that did happen. He did injure himself. It was a physical injury, and then he obviously has some mental impairment based on your argument. But why wasn't it brought as a mental or a physical mental?
Yes, Your Honor. Although it is a permanent injury, he was assigned PPD for a permanent injury, which must mean serious injury. After reviewing the reports of the doctors, it appeared that the physical components was better conceptualized as a criterion A event where serious injury was sustained. Your Honors, I do want to address, Dr. Abisi did not need to testify whether or not he reviewed the 30 days prior or something more. As the court held in Jutnin, the CAPS 30-day test is designed to only look at those 30 days. And the structure of his report, if you look at the CAPS 5, which opposing counsel vehemently suggests he adhered strictly to the rules of the CAPS 5, says if you're doing a lifetime analysis, you have to identify for worst month. you have to do 2 reviews of symptoms. So his opinion was clearly limited to the 30 days. To the extent he tried to offer a broader opinion, well, his statement about, I can't tell if he ever developed PTSD based on all the documentation shows he offered an opinion without foundation, Your Honors.
I want to ask you about this disciplinary thing again.
Yes, Judge.
I understood your argument about, well, if the doctor says he has PTSD, then by definition of the DSM, it's not from a disciplinary action.
Yes.
Short summary. The statute and subdivision 16 of 176.011, which is about personal injury, not PTSD necessarily. I just had it tabbed and I lost it. Subdivision 16, personal injury, and this is right in that statute. Mental impairment is not considered a personal injury if it results from a disciplinary action, work evaluation, blah, 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 taken in good faith by the employer. So we can forget about the definition of PTSD in the DSM or even in subdivision 15 and just look at subdivision 16. And then we've got this finding 51, which I realize you appealed. But if we find that there's substantial evidence to support finding 51, that the symptoms or as a result of the disciplinary action, doesn't this statute pretty much end it? We don't even have to deal with the presumption. We don't have to deal with anything in subdivision 15. We're just dealing with 16.
No, Judge. Legislatures, like lawyers, sometimes put in superfluous and belt and suspender type language. The injury asserted was PTSD. By definition, that mental impairment cannot be from a disciplinary action. Dr. Thackeray found it wasn't. Dr. Eckberg found it wasn't by the fact that he diagnosed PTSD. And Dr. RBC, in his report, criteria A, he finds it's met in 4 different instances. So his analysis is not limited. Criteria A doesn't have a time limit, but he finds in his report 4 different criterion A events, and that's what the decision hinges on, Your Honors. No criterion A, but there is.
Mr. Harrison, you're out of time. Judge Carlson, do you have any questions?
I don't, thank you.
Judge Quinn?
All done.
Thank you.
Thank you, Your Honors.
Mr. Harrison, about a minute.
Thank you. At the end of the day, the question is whether the substantial weight of the evidence supports the determination of the compensation judge. And we contend it does. And whether the court looks at it because of the criteria A, which if the court supports the determination of the compensation judge on criteria A, then it doesn't have to go any further because by definition, you couldn't have PTSD if you don't have criteria A. If the court goes beyond that, the determination of the compensation judge is still supported by the substantial weight of the evidence. And I would agree that if the court analyzes the definition of PTSD under subdivision 15 or subdivision 16, that to the extent, and the compensation judge does comment on this, to the extent that the claimed mental impairment is the result of a disciplinary proceeding, that is not a compensable occupational disease or personal injury under the statute, and that's statutorily. And so for all of those reasons, it's our contention that the substantial weight of the evidence supports the determination of the compensation. Thank you.
All right, the Martinez Cruz versus Metro Transit Police case is a case that the record is closed on, and we are adjourned. Thank you, Council.
Thank you.
The matter will be decided within 90 days.
Thank you.